friends, Namaskaram. How are you? My name is Dr. Jinesh Soni. I am a defense counsel. In today's class, we will discuss about Section 143A of NI Act. Whenever we fight a case, means contest an application concerning Section 143A of NI Act, we got panic or terrified because in absence of legal knowledge, it becomes impossible for us to contest such application. So first of all, we have to understand the nature of Section 143A of the NI Act. In addition to this, we have to understand the various points which are required to be pleaded so that we could effectively contest the application. First of all, we have to note down the judgment of Honorable Supreme Court, that is 2024 INSC page number 205. In that case, it is specified that the power is totally discretionary in nature. It is not mandatory. Honorable Supreme Court specified that the power can be invoked, but to invoke the same, specific grounds must be on record from the side of complainant. The merits of the case is required to be evaluated, in absence of which, if order passed, it would be mechanical in nature. So, simply we could say that the power can be exercised before conviction. The appellant court cannot exercise the power of Section 143A of the NI Act, and apart from that, if the amount so ordered is not paid, the recovery amount can be done through a process laid down in Section 421 of CRPC. In addition to this, the proper reasonings must be on record. If there is no reason, order is mechanical in nature, we could take the benefit. In addition to this, the concerned complainant has to establish the prima facie case. If there is no merit in the case, the allegations are vague, general, omnibus, we could take the benefit. In addition to this, your defense is required to be considered, and you are having the right of being heard on such application. If your stand is proper and you are according the plausible explanation, in that scenario you could be succeeded. Apart from that, you may submit the stand regarding your financial capacity. So, in nutshell, we could say that the defense also plays an important role regarding the success of application as per Section 143A of the NI Act in favor of defense, means accused. Apart from that, we have to understand various parameters regarding the application of Section 143A of the NI Act, and if you are contesting the application, then what parameters which are required to be abated by us so that we could be succeeded in such application. As we know that Section 143A of NI Act has been inserted by the way of amendment. So the prime attack of the concerned complainant is that the accused is causing delay in the case. He is not having the proper stand, and apart from that, he is having the merit in the case. So on these parameters, he may submit to the concerned court to intervene and to pass the order in his favor. This is basically called the psychology of complainant. And we have to submit certain point to sustain our defense mechanism. Number one, we have to support that there is no delay on our part regarding the proceeding. We have submitted the application as per due process. So basically, whenever we are going to submit an application to secure our rights, in that scenario, it could not be assumed that we are causing a delay. Delay means when witness is available, we are not available for cross-examination. We are deliberately avoiding the proceeding. These are the instances of delay. And you have to support your argument with the help of order sheets so that you could have effective stand on the record. And apart from that, you have to specify that you have given the proper reply to the concerned notice. So it is my humble request to all of you to give the proper reply to the concerned notice given to you by the concerned complainant at the inception, means before initiations of the proceeding. Regarding this, Section 94, Section 138, Subclause B of NI Act are quite important. If your reply is not specific, your reply is general, in that scenario, you could not rebut the presumption of Section 118, Section 139 of the NI Act, and apart from that, if you have taken the specific defense, in that scenario, the burden shifts on you. So, if you fail to give the reply, in that scenario, the court may draw the adverse inference. In that scenario, you might be liable. For this, you may peruse Section 119, Subclause Z of Bharati Saksha Adhiniyam. And apart from that, we are having the verdict of Honorable Supreme Court, that is 2010 Criminal Reporter, page 444. In all these legal positions, it has been specified that If the concerned accused failed to give the reply in that scenario, adverse inference could be drawn. So, in that way, you might lose a good case at hand. And apart from that, you have to specify that there is no merit in the case of complainant. It is totally concocted, it is based on general facts, it is totally omnibus. As we know that the powers are not mandatory, it is discretionary in nature. So we could attack that there is no legal enforceable debt. The check is not issued by you, and the account from which the check is alleged to be issued never belongs to you. There is no service of notice to you. And apart from that, you have given the proper reply, and there is no rejoinder on the part of complainant. In that scenario, we could submit our argument before the concerned court. But mark my words, do not submit the ocular reply, submit the proper written reply. And apart from that, we are not supposed to raise our defense beyond reasonable doubt. We are supposed to raise our defense on the touchstone of plausible effect. So if your defense is probable, it is causing the plausible effect, we could be succeeded. For example, if Mr. A says that the check is given against a loan is of rupees 1 lakh, and you have shown that the amount has been paid off, and you are having the ample evidence, and the said scenario has not been endorsed by the concerned complainant, then we could be succeeded because our defense is causing a suspect, means a plausible effect on the case of complainant. In that scenario, the application is liable to be rejected. So in this way, we have to proceed and have to submit our argument. See you in the next video. Till then, Jai Hind, Jai Bharat.